Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today we've kept a very special format. It will be a casual conversation kind of a thing on the law of torts, civil litigation and arbitration. And joining us today on the Virtual Amicus is someone who needs absolutely no introduction. He is known for his assertiveness and his lucid arguments in the courts of law. And just to give you all a brief introduction about our amicus, Mr. Akshay Sapre. He's practicing as a counsel in the field of domestic and international arbitration, corporate, and specializes in corporate, writ, civil, and taxation matters. He's also an author and editor for LexisNexis Group, having worked on titles such as Sale of Goods, Law of Torts, Information Technology and Advocates Act, prescribed in the syllabus for the Advocate on Record examination conducted by the Honorable Supreme Court of India. On the academic side, he's associated with William C. Wyss International Commercial Arbitration Moot Court, Vienna, and Center for International Legal Studies, Salzburg, Austria, as arbitrator since 2014. He graduated back, he studied law and did his BA LLB honors from the very prestigious National Law Institute University, NLIU Bhopal at Madhya Pradesh, India. And he's obviously specializes in commercial arbitration, civil writ service, taxation side before the Honorable Supreme Court of India and various tribunals. And he has a clients that range from arbitration, corporate houses, electricity, general writ service, natural gas, consumer, national highways, telecommunication, excise, and you name it, and that list would feature in it. And as far as books and publications are concerned, several key books that I wish to mention. He's also the revising author, Pollock and Mullah of the Sales of Goods Act, 11th edition 2021, LexisNexis. Revising author, Ratan Lal, Dheeraj Lal, Law of Torts, 28th edition 2019, LexisNexis. And the list goes on, and has several reported judgments to his name, not just before the Honorable Supreme Court of India, but also the High Court of Madhya Pradesh, Allahabad High Court of Chhattisgarh, etc. and etc. So thank you so much, sir, for taking our time for doing this fun chat session on the law of torts, civil litigation, and arbitration. Sir, anything that you wish to say before we start with our segment?
Thank you so much. And that was quite an introduction. Jay, you can make anyone look good. Thank you so much for your kind words. And in fact, I must congratulate you for all the good work that you are doing and assimilation of so much of information and knowledge and opinion of different people. You've already gathered about 95 different people, and that's actually a very, very good effort that you are doing. It's something for posterity and something for the future generations if YouTube still survives. But thank you for calling me to talk on torts, which I believe is a fading field. But let me tell you, this was one of the most or one of the oldest branches of law, which far earlier than our constitution and everyone who got into the writ mode. And this is the foundation principle of what common law is. The basic element, this is for your younger generation, not for lawyers and the seniors and at the bar, because they know, of course, they know far more than me. But for the younger generation who is entering law school, who will be taught torts and unfortunately will forget after the first year. So torts is basically a civil wrong. Why is it called a civil wrong? Because the moment you impute some intention in causing harm, it gets into the realm of criminality. So it does not remain a civil wrong there. But to understand torts, see, we must understand that it regulates the behavior of people in society. How does it do it? Because I owe a duty of care as a reasonable person to my fellow being. I can't be negligent in my actions. I can't create a ruckus. I can't put somebody else in trouble, or I can't, by my own acts, do something which will cause harm to the other person unintentionally. The moment I do it intentionally, it gets into the realm of criminal law, as I said. So the basic theme of torts is behave yourself in the society. When you are surrounded by other people, you keep yourself into limits and don't create a nuisance or act negligently or do anything that will harm you. Now, very interestingly, there are a lot of principles in torts, and you know how I thought that let's talk of torts. It's because of this very episode, because this is a clear case of voluntary non-fit injuria, one of the principles of torts. where you put yourself into a position knowingly that it will cause you harm. And like your channel has been doing very well up till now. You've recorded about 95 episodes. Your YouTube channel is going good until you called me here. And knowing full well my propensity of saying something nasty, which will actually take down your viewership, or even worse, YouTube taking down your channel. So you knowingly put yourself into a position where your channel may be at risk. And if you were to go to court, I have my defenses ready. That, look here, you knew what my propensity is, and you put yourself into that position, and your channel will now suffer. So this is like a bull charging down the road, and you go and stand in the middle of the road, knowing full well that it will hit you and it will injure you. So, but talking of that, if you were to actually go to court, the problem is that you will go to a civil court. You will not go in a writ. You will not go into arbitration. So that is what what I also wanted to talk to you about, is that why torts has not developed in India. And I found two blameworthy reasons. The reason also needs to be blameworthy. It has to be worthy of taking the blame so that it feels nice about it. That one reason is, of course, no awareness. Like, people don't know what their rights, tortious rights and tortious duties are, because that is taught in a way that you forget it. And that is not really the meat of the practice of today's time. It used to be, but not anymore. So lack of awareness, no interest in it. And the second, for those unfortunate people who are aware of what their rights are, I call them unfortunate because their remedy will lie in the civil court. So tomorrow, if you were to sue me for the downward trend in your viewership of this channel after this talk, you will have to file a suit. And that suit under CPC, that will take years on end to get concluded. And it is that trial which actually becomes the punishment for you. And tortious claims are not as, there have been, of course, instances where the tortious claims have been huge, like the Union Carbide, etc. But on a day-to-day basis, a tortious claim is not worth, people think that it's not worth their time spending 10 years in court, getting a decree, and then spending another 10 years executing that decree. Because it is difficult, it is difficult to get a suit decided, even more difficult to get a decree executed. Because you see, Order 21 in CPC, it has 100 odd other rules for enforcement of a decree. And one rule at the end of it, Order 2197, comes where somebody can just spring up and file an objection to a decree that I have to be heard. That objection is decided, results in another decree, goes in appeal, comes back. So it's a rigmarole for a civil litigant. So torts as a subject, it's very interesting, but unfortunately has not developed. And in other jurisdictions, if you see, England and other common law countries, torts is actually taken so seriously, not only in the day-to-day life, but even right up to the House of Lords and Supreme Court. Because when I work on torts, I find more judgments there than our own country. That is because the time taken in courts is so much that it really frustrates a person. So, not just to be an armchair critic, what a possible solution could be is you categorize torts as a commercial dispute under the Commercial Courts Act. If you examine the Commercial Courts Act, you have a definition of commercial dispute. And in that, you have certain categories of matters which can fall under commercial disputes, including admiralty and maritime, etc. But if you include torts also in the commercial dispute, at least the benefit of it would be that the pace of the civil suit will be faster. And at least you can see the color of the decree or the fruits of the decree faster than a regular suit. And it is well possible, I'm just thinking out loudly, that it is well possible to do it because ultimately a tortious suit is nothing more than a monetary claim. Your damages, you ask for damages and your damages are monetary. And that results in a money decree. So why not categorize that also as a commercial suit? Right. If you have anything to add on to this or to.
So broadly, I think you made some really very important points with respect to how the remedy that lies, is itself a punishment, a deterrent for a litigant to approach, because the remedy lies before civil courts. It's a civil wrong ultimately, and the possible solution could be, and it obviously takes years and years to first get and enjoy the fruits of that degree, and then subsequently years and years to get it executed.
That's right.
Orders and rules that are enshrined under the Civil Procedure Code, although beautifully drafted, but the execution part takes a lifetime. And even probably, sometimes at some stage we even need to bring in the legal res of the.
Oh yeah. Oh, that's a very, very different story. In
That is
fact,
very unfortunate.
I call it, see, civil litigation, I call it like Squid Games. Once you've entered, then it is very hard to exit.
At least one will get eliminated and his heirs will come on records.
Exactly. So unless and until that civil litigation has wiped out 1 or 2 generations, it can't get concluded. So the legal heirs step in, or some or the other person is impleted. Then there also comes a problem that can the legal heir take a different stand than their original plaintiff or the defendant, because now situations have changed. So civil litigation is actually like Squid Games.
That was, wonderfully melodramatically put. And also, sir, the possible solution that comes from you, from our expert Amicus, to all the viewers who are watching, is that it could be categorized as a commercial dispute. So at least it doesn't take years and years for commercial courts to decide, because under the category of, under the definition or under the head of commercial disputes, if there's an amendment that is made and then it is brought in, I mean, things can be much better in terms of execution, and you can even enjoy the fruits of the degree that comes out. Now,
in fact, not an amendment. There is a particular provision under the definition itself that the central government may notify a particular category of dispute.
Okay.
It can even be by way of a notification.
By way of from the central government.
From the central government, correct. So if that is done, at least things get expedited, and that inspires some confidence in the litigant. That if I go to court today, I don't have to wait for like 2030 to get a decree in my favor.
Absolutely, sir. Now that, sir, we've covered torts, we've covered civil litigation and the connection between the two. Because I've mentioned arbitration, so we will have to speak something about arbitration, because all the viewers, they gun me down, like what happens in Squid Game. So what's the connection, sir? It's non-contractual dispute, where that is where tort comes into the picture. So why did we choose arbitration? Is it possible for two parties to enter an agreement and decide on a particular quantum or a sum, when we know that as and when agreement comes in, the concept of torts is wiped out, because torts itself means that it's a remedy for a non-contractual.
Absolutely right. You're absolutely right. See, because arbitration, the basic thrust of arbitration is that there has to be, the way arbitration is conceived nowadays in the 96 Act or even in the 40 Act, that you need to have an arbitration agreement. You need to, and that arbitration agreement has to be in writing. It may be even in a series of communications, but there has to be an intention to arbitrate. Now, two random strangers coming into a tortious act may not have the intention to arbitrate at all, may not even know, let alone intention to arbitrate. But the kind of arbitration scenario that we have, I do not think, it is my personal view, I do not think that it can handle a tortious dispute, because that arbitration will fail, that I don't consent to an arbitrator at all. Where is the agreement in writing? If you file a suit for a breach of contract and there is an agreement to arbitrate, the court can under Section 8 send you to arbitration. But in a tortious suit, there is no agreement. Right? But in a jurisprudential sense, completely academic in a jurisprudential sense, you can press into service the social contract theory, which says that everybody is in agreement with each other to live in a society and recognize the existence of a state, and that state can then arbitrate. But that is completely in a jurisprudential sense, and I'm sure Hobbes, Locke, and Rousseau will be turning in their graves if we do it because they did not intend to do it. But arbitration could be one of the remedies. If not arbitration, but mediation can be one of the remedies for resolving a tortious dispute. And that mediator must pass perhaps an award, or must pass an opinion, or must pass a judgment or something which should be made enforceable. Because at least the parties are mediated to resolve a dispute that has culminated by way of a judicial or a quasi-judicial process with consent of parties, and that whatever award is passed, it has to be a monetary award, that has to be made enforceable as a decree of court. But then again, as a decree of court, you go to civil court. So that, which also, interestingly, you've raised arbitration. Do you know who is the most helpless person?
After me, sir.
Well,
I top the
after
list.
you or in addition to you?
In addition to me,
The most helpless person who
the
comes
judge who's
to
dealing
me.
with Section 34.
Yeah, absolutely. The most helpless person who comes to my mind is that learned judge who's dealing with the Section 34 application. Because 34, if you read, it is not an appeal. The words of 34 is recourse to an arbitral award, recourse to court against an arbitral award. And you can go to court only on certain grounds enumerated in 34. You can't go beyond that. So it's not an appeal. That judge cannot exercise appellate powers. That judge can't remand. There's a gray area whether it can be remanded to the same arbitrator or not. That judge can't impute his own or her own wisdom and replace that the opinion of the arbitrator. They can't vary or distinguish findings. So what can the judge do? I mean, after an award is brought to him or her or them, what can the judge do? They can simply uphold or set it aside. So the role of a judge is he's so bound by the language of 34 that I find that person is the most helpless person in the world. So there has to be some leeway to the court to do something. I mean, you either uphold it in part, or you reject it in part, or you do something. But again, you can't remand it to the same arbitrator, because that person is functius officio, as they say. That once the proceedings have culminated, it comes to an end. Then that person is a stranger to the dispute. Then once an award is set aside in 34, where either you go up in appeal 37, go in SLP. But if not, then where do the parties go? They're again back to the square one, where they started from. You again start arbitration, you again arbitrate for about a year. Thankfully, now there is a year-long deadline. But that also has been diluted, that a year from completion of pleadings. So, so it's really, I mean, even if you take a tortious dispute to an arbitration and you go in a 34, what will that judge do? That judge can't really do anything. So unless and until you streamline that process, even a person in a contractual dispute, to see the color of money and the fruits of that award, which is now enforceable as a decree, it is a very uphill task for that person.
So the two possible solutions, sir, that you pointed out, perhaps that could expedite and that could ensure smooth execution, could be one, to categorize it as a commercial dispute, which even the central government can do by way of a notification, and it need not be an amendment that the parliament has to pass. And two, there could be something like a mandatory pre-institution mediation, wherein parties enter into mediation and then they see, and subsequently after a failure report, they can contest the matter on merits under the umbrella of Commercial Disputes Act. Possible solutions.
Possible solutions.
Because ultimately, everybody wants to see the color of money, the enjoy the fruits of the decree, and then they can possibly do that if at all this happens. Now, sir,
yes, not just the color of money. At least the litigant, it must inspire confidence in the litigant. That if I go there, I have had my rights vindicated. And at least what I was fighting for, I've gotten it. Whether it is in terms of money, whether it is in terms of declaration, whether it is in terms of just winning that particular litigation, at least that kind of satisfaction is inspired.
So to add to that, there are certain torts that also qualify to be criminal offenses under the Indian Penal Code. For
Oh, yeah.
example, trespass, any offense that is meant to harm or threaten any individual's body, for example, assault, battery.
That's right.
Now, is the difference only of intent, or is there anything else that results in a tort qualifying to be a criminal offense, liable to be prosecution under the provisions of the Act? Is it just the intent, or it is?
Yeah, to my mind, the distinction between torts and criminal law is intent. The moment you have an intention to cause harm, if you are able to establish that there is an intention on my part to cause you harm, I get into the realm of criminal law. And the moment there is no intention, it was a completely rash and negligent act. Like under the Motor Vehicles Act, there is a no-fault liability. Like torts is not a codified law, but certain elements of torts, like consumer protection, that is codified. Certain elements of torts under the motor vehicle, that is codified. So you need to establish intent to get into the realm of criminal law and get out of torts. But there is an overlap there, like defamation is tortious also, defamation is criminal also. The rash and negligent act can be tortious also. The moment you impute intent, it can be a criminal act also under IPC. So
Even
there is
negligence, sir, for that matter.
even negligence, yes, even negligence, of course.
But there's a duty of taking care, and then once there's a breach of that duty, taking
Correct. Absolutely, absolutely. So this is precisely the principle under the medical negligence also. That if the doctor has exercised all duty of care as was expected of a particular of his stature, and if there is no breach of duty of care on their part, then it is not a criminal offense on that part. But if the doctor was negligent and intentionally negligent, which has costed that patient some grievous hurt or maybe the life of that patient, then certainly it is an offense. So there is a long line of judgment. Jacob Matthews and all your viewers can see. I can't possibly add more to that, but there is a judgment. You pick it up. It's a good judgment to read.
Absolutely, sir. So to all the viewers who are watching, tort law is not codified in India. What do we mean by codification? To codify means to arrange a set of laws, a set of rules into a systematic code where punishments are defined, where the offenses are defined. For example, criminal law is codified because there are punishments that are defined. That for 302, this is the punishment. For 304, this is the punishment. Because tort law is mostly jurisprudential based. And sir, anything that you wish to add before we wrap up, or the coolest session that I've ever recorded on the virtual Amicus with the finest speaker?
Well, see, torts is interesting because it is not codified. And if you have a section in front of you, you can read the section and you can apply it to a set of facts and interpret it in a way that will suit you or that will discredit the other person. But in torts, you don't have a section to read and to interpret. So that way, it is just the gamut of facts in front of you that you need to interpret. And that actually is a very good exercise, that how you interpret the factual situation, how you adduce evidence, and how you plead your case based on the facts and make out a position in torts. And that actually helps us in learning about how drafting and pleading works. Because I don't know, I must in fact tell you, there is a book on pleadings called Mogha's Law on Pleadings. That comes to my mind, that where Justice Mogha, he was a district judge, so far as I remember, and this was early 1900s, I believe, and he wrote a book because in his preface, if you see the book, in his preface, one line he says that the plaints that came in front of me were singularly lacking in pleadings. So that actually compelled him to write the book on pleadings. So it is very important that you know the art of pleading, and drafting a tortious claim will really help. I can only say that practice on the original side and to develop an interest in torts. At least that is the foundational principle of our common law.
Absolutely, sir. So thank you so much, sir, for doing this session for us. It really means a lot for me and my entire team. And to all the viewers who are watching, it is so important to be proactive on the academic side as well, because sir has been associated with such prestigious moot court competitions. He has been, editing, and he's been a revising author to such famous publications. I think that is what makes all the difference. To all the viewers who are watching, it is so important to be. So it is so important for everyone, who's watching, to be proactive on the academic side, to keep that spirit in you alive, and that is pretty much makes all the difference. So thank you so much, sir. That clarity of thought, for doing this really very important session for us, and really means a lot to me and my team. And our email is mentioned on the channel. To all the viewers who are watching, feel free to write to us, and we'll be more than happy to forward the same to our Amicus for today's session, Mr. Akshay Sapre. Thank you so much, sir, once again. It's goodbye for now.
Thank you. Thank you so much, Jay. Have a nice day. Thanks.